Judge, I stand before you to make closing submissions supporting the application of an occupation order attached with a power of arrest under Section 33 of the Family Law Act 1996, and for the continuation of a non-existing non-molestation order which was granted on the 3rd of May 2024. The existing non-molestation order, which was granted on the 3rd of May 2024 under Section 42 of the Family Law Act 1996, requires continuation to safeguard the applicant and her children from the actions of the respondent. On multiple occasions, the applicant has experienced violence, harassment, and intimidation from the respondent. The respondent has displayed extreme violence towards the applicant by physically assaulting her shortly after the birth of their child. Despite this incident occurring 3 years ago, it indicates a pattern of the respondent using violence to intimidate the applicant when facing disagreements. Subsequently, the respondent has continued to resort to violence, involving grabbing the applicant by the neck and potentially wielding a knife while she was corded against a wall on a separate occasion. The respondent has been verbally abusive through shouting, threats, and using degrading language, such as flighty cow and a hopeless mother. In regards to threats, the respondent has used phrases such as, "If I can't have you, then no one will," and you're not going to stop me from seeing my kids. Pull a stunt like that again, and you're dead." The usage of these phrases have affected the children. For example, the children were described as hysterically crying as they were witnesses to this verbal abuse. This falls under Section 42, subsection 5, subsection B, which states that the court shall have regard to all circumstances, including the secure health and well-being of any relevant child. Health can also be defined, it can also include mental as well as physical under Section 63, subsection 1. Another example is depicted in the applicant's daughter being woken up and crying due to the respondent banging on the bedroom door. Moreover, the respondent has resorted to other forms of harassment. For instance, the applicant receives frequent nuisance calls, particularly silent telephone calls. The respondent repeatedly bothers her by loitering outside her residence. She describes the respondent as grinning in a way that frightens me. In conclusion, the non-molestation order should continue, as it is evident that the respondent has displayed inappropriate behaviour towards the applicant and their children. With regards to the occupation order with a power of arrest, the applicant has provided compelling evidence demonstrating the necessity for an occupation order to be granted under Section 33 of the Family Law Act 1996. Both parties are considered to be associated persons, as they are spouses. However, the applicant does raise the fact that she initiated divorce proceedings and therefore are soon to become former spouses. And the applicant is entitled to occupy the home, under said section 33. The respondent's repeated and escalated incidences of abusive behaviour have created an environment of fear and instability. The applicant and her children deserve the security and peace of mind that comes with the occupation of the home. Moreover, the respondent has another place of residence in Bristol with his family, whereas the applicant is unable to move due to her parents' small home and her friends not being able to accommodate her and her children. Another factor that the court will take into consideration is the balance of harm test, which is listed as under Section 33, subsection 7, which states that it must consider the likelihood of significant harm to either party and any relevant child if an order is made, and that is balanced against the likelihood of significant harm if a significant order is not made. Due to the respondent being extremely violent and abusive, it is evident that the likelihood of the respondent displaying displaying this behaviour towards the applicant is very, very high. In addition, the children have already witnessed the abuse from the respondent, which already has caused them to react in a negative way. Therefore, the well-being of the children must be protected, and therefore this occupation order should be made. The power of arrest associated with this order is crucial. This enforcement mechanism ensures that the occupation order remains effective and not undermined. It is essential for the safety and well-being of the applicant that there are immediate consequences if this occupation order is breached. Now, with regards to the respondent's arguments, this can be summarized into 3 points. The first point the respondent makes is that the applicant has been verbally abusive and physically abusive towards him, calling the respondent phrases such as "you're half a man," and on one occasion she scratched the respondent's face with her nails, and in self-defense he pushed her up against a wall. But this does not undermine the fact that that the applicant has already stated previously that the respondent wielded a potential weapon against her, therefore escalating the violence even further. All the applicant did from the respondent's arguments is that she only scratched him. A scratch and wielding a weapon are two completely different scenarios. A knife is way more serious. And secondly, with regards to this first argument, the children who are involved have already witnessed the respondent being verbally abusive to the applicant. Like I said, has already been verbally abusive to the applicant in front of the children, and the children have already responded negatively to that by crying. The second argument the respondent poses is with regards to residence. As I've stated previously, the respondent does have residence in Bristol, but he states that under paragraph 7 that he was only able to stay in that residence for an indefinite period of time, as the house in Bristol is cramped, and he was forced to leave and return back to the marital home. And he also pays a mortgage on the home, and therefore if he did leave the matrimonial home, how much he pays and how much he earned, which is £1,200, it won't be enough for him to pay for alternative accommodation. Now, in relation to this argument, as I've already stated previously, the applicant does not have anywhere to go, so therefore she is entitled to stay in that matrimonial home, as she has nowhere to go, and her parents and her friends are not able to accommodate her in their own properties, whereas the respondent does have an alternative to move if he needs to. And the final argument that the respondent poses is the fact that the applicant has a boyfriend, and the reason why the applicant wants him out of the house is because she wants to move the boyfriend in to the home, However, under paragraph 2 and 3 of the applicant's statement made on the 13th of May, she says that she already informed the respondent. She already informed the respondent of her having a new relationship, and that the reason why she never told the respondent with regards as to where he lives and his personal information is that she was also frightened for her new partner's safety, as stated in paragraph 4. He grabbed both my arms and pinned me against the sink. He was clearly drunk and angry. He demanded to know where Andrew's name and address. He demanded to know Mr. Andrew's name and address. I was very frightened and I tried to struggle free. This little incident again further proves that there is a pattern that the respondent uses violence in order to intimidate the applicant and and to also to intimidate the applicant when there is a disagreement. So therefore she never really therefore her worrying about her new partner's safety and what the respondent has already done, this further reinforces the need of the occupation order to remove the respondent from the home as it is essential to safeguard the applicant's physical and emotional well-being. Judge, both the occupation order with the power of arrest and the continuation of the non-molestation order are essential to the safeguarding of the applicant's physical and emotional well-being. The evidence presented confirms that the respondent's behaviour poses a serious threat that must be mitigated through these legal protections. I urge the court to grant these orders to ensure the applicant, her children, and her new partner's safety are upheld. The gravity of the situation necessitates decisive action to prevent further harm and to uphold the protection the applicant rightfully deserves. Thank you.